Hello guys and welcome to LawPutra's YouTube channel. Today we will discuss about the doctrine of justice, equity and good conscience. We might have observed in many cases that in our written statements or pleadings we mention the last line for the court, we pray to the court to pass the orders with the justice, equity and good conscience. I am Jagannath Kulkarni and today we will discuss about this doctrine. If you want to see this justice, equity and good conscience, obviously we need to go to the basic, that is Constitution of India 1950. Two articles are very important while we discuss this doctrine. The first and foremost article is Article 21, which talks about protection of life and personal liberty. It says no person shall be deprived of his life or personal liberty except according to procedure established by law. And this is important article, and the basic decisions all the based on this article are referring to the justice, equity and good conscience. At the same time, if we refer to article 142, which talks about the enforcement of decrees and orders of Supreme Court and orders as to discovery, etc. This article has got two clauses, clause 1 and clause 2. If we read these clauses very carefully, we will find that the Supreme Court is supposed to pass orders as is necessary for doing complete justice in any cause or matter pending before it. So this is the Article 142 strength, which refers again to this doctrine of justice, equity and good conscience. Now let us talk about the meaning of it. What is meant by justice, equity and good conscience? If on a particular point of dispute before court, any court, may it be lower court or the Supreme Court, and if there is no express law or parliamentary law, no regulation also, and if it fell outside the heads for which Hindu laws and Mohammedan laws were prescribed, then court was to decide the matter according to these three principles: justice, equity, good conscience. Actually, the British brought this concept in our country. And if we see how it started, this doctrine, it was first introduced in our country, India, in Presidency of Bengal, because the British era started there from in 1780, long back in 1780. Then it transplanted in Mofussil Presidency, Mofussil courts of presidencies of obviously Bombay and Madras. And then later on, they have been introduced in other territories of India. So it started in Bengal in 1780, then Bombay, Madras Presidency, then other territories. British started this principle. But let us see when it is applied. Right? It was application in 1862, and this was the case, first case, Vardhan Seth Sam versus Lakpati. And Privy Council said in this case that a company's courts did not have properly any prescribed general law to which their decisions must conform, and that's why they were directed to proceed generally according to these three things, principles: justice, equity, good conscience. So it is the discretionary power of the court, power of the judge, jury, whoever is delivering the justice has to apply these three principles: justice, equity and good conscience. Also, now let us see in detail what is meant by these three things. First, let us see what is justice. Principle of justice, this word itself is come from the Latin jus, which means right. And it is the best indicator of a country's political success is the way it administers justice. So that political success of the country can be measured how it is administering the justice. Not merely right determination and adjudication of disputes, enforcement of law, but so comprehensive in its meaning and import that it takes within its ambit whole of political, juristic and moral idealism. So this is meant by justice. Who said? Professor Sidgwick said about this. And he also mentioned that every culture has its concept of justice. So different cultures, different concepts. In India, if we refer to the Vedic period, our legacy, we can find the perennial attitude of Indian culture, which says justice and righteousness among men are microscopic reflections of natural order and harmony of macroscopic universe. So if it starts with the individual, it will automatically cover the world, the universe. If we see the divine theory, then it says John Stuart, utilitarian thinker like John Stuart, he said justice issues from God. That is a divine theory. But again, the John Stuart said natural law. John Locke said that it is a natural law. Justice is the natural law. So when we say justice, it is a natural justice, natural law. Now let us see what is meant by the equity. It is a set of rules. It is neither originated from customs nor from statutory law. Then it is formed on basis of dictates of conscience decided in court of chancery, where common law was not applicable, and chancellor presided over such cases in special courts. Even those courts were to be called as the equity courts, which will be having separate existence from common law courts in England. And that courts, equity courts, they acted on a number of customs. What are the customs? Simple. Who seeks equity must do equity. Number one. Second, who comes to equity or comes for equity must come with clean hands. So whoever is seeking equity must himself has practiced equity. Now let us see what is meant by the good conscience. Third principle. It says knowledge of one's act, state, character, whether it is right or wrong, and faculty or principle which determines whether a particular action by a person or by the institution is lawful or unlawful. If it is lawful, we'll approve it. If unlawful, we'll condemn it. 16th and 17th centuries, we need to go back. Lawyers in England, they talk about the collection of universal principles which have been gifted to mankind by Almighty to apply by reason. So that was about the good conscience. And it is the reformation of medieval Roman law based system forms of which is reflected in forms of actions, written pleadings, and use of judicial pattern of litigations. So this is about the third principle. Now let us see what were the advantages, disadvantages, right? So first advantage, it is helped in development of various branches of law which were not covered by Hindu law or Muslim law because these were the personal laws. In absence of sound provisions of personal laws, it served, this justice, equity, good conscience served as a valuable source of sound law. It removed uncertainty in law, and the distinction between Mofussil law, presidency towns law removed. So these are the advantages. What was the disadvantages? At times, the rules applied by English judges, because in those times British people were the judges, they were not consistent with customs, habits, circumstances prevailing in our country, and that's why they were technical in nature, and which generated injustice, felt injustice. And then it led to judicial legislation by rules which were foreign to India. British applied their rules, but Indians may not be accustomed with it. Now, the general idea behind this custom was, if on a particular point of dispute before court, no express law or parliamentary law, no regulation, and if it fell outside the heads for which Hindu laws or Mohammedan laws were prescribed, courts was to decide the matter according to these three things: justice, equity, good conscience. Let us see what it means. We say justice can mean equity. Justice can mean equity, but equity does not mean justice, right? Justice means fairness. Fairness means fair treatment is just treatment. And what is just treatment? It is the treatment according to need of a person, and that is equity. And we say justice is consequence of applications of principles of equity. So these are the intertwined principles. Also, let us see what Lord Atkins said. He said, might is right. Even today we observe this. Might is right, but law is might. Law is above all, we say. And then justice is right, but justice which is natural justice, which makes the justice, which makes equity, is mightier than might. Very important. Justice has to be natural justice, then only it will be mightier. in these things. So today we discuss about this doctrine just of justice, equity and good conscience. Thank you. Thank you very much.